Good morning and welcome to Multnomah Group's latest webinar, Best Practices for Retirement Plan Fiduciaries to Mitigate the Risk of Litigation. My name is Eric Daly. I'm joined today by Bonnie Treichel. We're both consultants with Multnomah Group working on fiduciary issues and investment solutions for retirement plan clients. Before I get started, a couple of housekeeping items. We have muted all the lines on today's webinar to try and improve audio quality. That said, we do encourage questions throughout. So you'll note within your GoToWebinar control panel, there is a questions section. Please feel free to add questions throughout the course of the presentation, some of which we may answer during the presentation. Others we'll try and get to at the conclusion of our prepared remarks today. The second is that we are recording today's presentation. So if either you miss elements of today's presentation or you have the opportunity to review it with other members of your fiduciary team, please feel free to do so. We'll provide a link to that in the days after the presentation. And third is that we will be also providing a copy of the prepared materials for today to the attendees. So, don't feel like you need to necessarily take every note and write down every bullet point. We'll be happy to provide a copy of this over the course of the next couple of days. From an agenda perspective, we do have a few things we're going to try and talk through. First and foremost is kind of the litigation landscape, trying to provide some context to what we're seeing as it relates to fiduciary breach cases related to retirement plans. We're going to talk a little bit more about establishing and running an effective retirement plan committee. Clearly, that is one of the best ways to mitigate that risk, is having an effective committee and staffing it appropriately. Third, selecting, monitoring, and replacing investments and the process that goes along with that. And fourth, which is just as important, is the selection, monitoring, and replacing of the retirement plan vendors that you work with. We'll talk about the communication process. We'll circle back around with reporting back to the board in cases where fiduciary duty is delegated, and then we'll again open it up for some questions. I think it's important to have some framework or historical understanding of how quickly things are changing as it relates to retirement plans. I think if you look at the history of retirement plans litigation and what has us where we are today, there are probably a handful of things that are increasing with frequency and regularity, certainly over the course of the last several years. But first was back in 1963, which really created the need, or at least the perceived need, for the Employee Retirement Income Security Act. Back in '63, Studebaker Corporation collapses, and workers only get about 15 to 20 cents on the dollar of their retirement benefits. And clearly that created what had up to this point been an unknown risk had become a material risk. And as a result of that, a mere 11 years later, because legislation moves so quickly, we have the Employee Retirement Income Security Act, or ERISA, as we'll refer to it regularly throughout today's presentation. ERISA was very clearly a reaction to the Studebaker case and other concerns related to retirement plan liquidity and the promise of benefits, and how do we ensure that these promised benefits would be available for employees as they make it into retirement. Back in 1998, a federal judge certified the first ERISA class action suit, and it was brought by participants in the ICON Office Solutions related to company stock. So really the first time we began to see litigation related to employer securities, and certainly the first ever certification of a class action goes back to 1998. And really 1998 began, again, the snowball running downhill at a ever-increasing pace. Back in 2002, we had the very notable stock drop case of Enron. Add to that the WorldCom disaster as it related to employer securities and the impact that that had on retirement plan participants. But in the cases of Enron and WorldCom, we were faced with a situation where there was a perceived, not just a breach, but almost a fraudulent breach of fiduciary duty, not just the stock happened to drop and should you not have known that your stock may have dropped over that period of time. 2006, I think we had the first action of what has become a real material player in the ERISA class action litigation world, which is Schlichter, Bogart, and Denton out of St. Louis. They began the first in a wave of actions against fiduciaries challenging service provider and investment-related fees. So the fee spate of lawsuits, from our perspective, really began back in 2006, and Schlichter has made a good work in getting a large number of settlements brought against plan sponsors for breaches related to fees and monitoring of fees. 2015 began a wave of litigation targeting mutual fund companies that put their own investment products in workers' 401k plans. So for most of you on the call today, not a real issue because likely you don't manufacture your own investment products. But for those that did, it was not uncommon to use your proprietary funds within your 401k plan, which in some ways is sensible. You're out selling these investment products. If you're not willing to eat your own cooking, then perhaps there's a risk associated with that. But in the world of ERISA, it doesn't certainly preclude you from having to do review and monitoring of investment options in the plan, whether they're your investment options or someone else's. 2016, class action claims target plans using money markets in the low interest rate environment. So we had a 5-year period of time coming out of the economic crisis where money market yields were virtually zero. And we had class action litigation with claims related to the appropriateness of money market as an asset class, not a specific money market fund per se, but whether money market was an appropriate selection or alternative to make available to participants in a retirement plan. And then back in 2016, we had 12 higher education institutions accused of fiduciary breaches in what they hope will become class action suits against the fiduciaries related to those 12 retirement plans. So what you really see starting about 20 years ago, 1998, was a much more rapid development of case law and certainly claims related to and settlements related to fiduciary breach cases for employee retirement income security plans. And ultimately the reason is because it's been awfully good. It has been a great place to make settlement money. Not many of these cases ultimately get all the way into a courtroom where a court is provided the opportunity to provide judgment. So instead what we have is a tremendous number of settlements, some of which become easier because many of the plan sponsors ultimately have some level of insurance coverage, and if they would prefer to make this go away rather than to litigate what could be an expensive case, the opportunity to do that clearly is here. I think what's most notable is if you look at the attorney fees and cost pieces, how attractive this has been for those that have been in the process of identifying and representing class action litigants in employee retirement income security cases. A number of individual facts and circumstances, clearly fees being a big piece of those, and inability or at least an accusation of an ineffective plan to monitor and reduce expenses. But again, in many of those cases, 25 or more % of the ultimate settlement has been paid out to the attorneys representing the class action litigants. Litigation landscape. Ultimately, the 12 cases that have been getting a tremendous amount of attention most recently because they were brought in 2016 all within a day or two of each other were 12 cases brought in each of the district courts across the United States related to tax-exempt entities, specifically in this case higher education institutions, and some of the largest higher education institutions, at least from a retirement plan perspective, in the country. So you have Yale, NYU, Columbia, Cornell, Penn, Duke, Johns Hopkins, Vanderbilt, Northwestern, USC, and Emory. Ultimately, in these cases, there were an array of claims, some of which were specific to the providers that work heavily within that industry, and accusations about the product types, appropriateness, and expenses related to investment products. Certainly a tremendous number of claims related to the amount of revenue sharing. So whether you are in higher education or in the corporate space, you should be familiar with revenue sharing and how payments are made from mutual fund or annuity investment product managers to retirement plans and the costs that are incurred by participants in those revenue sharing arrangements, and that these plans failed to take seriously some of the revisions to best practice and tax code that came about as a result of the Internal Revenue Service changing laws and regulations pertaining to 403B plans back in 2008, 2009. None of these cases are anywhere near conclusion at this point, so it's difficult to learn a tremendous amount. But what is clear is that Schlichter continues to modify and improve the claims, obviously in hopes of pushing all of these potential defendants into the courtroom. At this point, I think all 12 of them are subject to a motion to dismiss, and it'll be obviously interesting to see if any or all of these particular claims, all of which were brought by Schlichter, as I mentioned earlier, one of the primary actors in the fee retirement plan ERISA breach cases against all 12 of these institutions. We think it's really important from a risk mitigation perspective to ensure that committees have a more holistic understanding of how their retirement plans run. Very frequently when we're brought into new engagements, what we find is committees that have regularly been monitoring investment performance, in some cases monitoring with at least periodic regularity fees. But if you go back to the prior page and really any of the claims, when you get a fiduciary breach case, it's never going to be a singular claim. It's going to be an array of claims brought against plan fiduciaries for failure to oversee prudently the retirement plan and its operation. So over the course of the year, I think it's important for committees to touch on as many of the potential risk items from a fiduciary breach perspective as is humanly possible. So what we've done here is put together a potential calendar for any like-minded client, where in the first quarter you're certainly looking at investment performance, but you're really also focused on your governance structure. Do we have the right people? Are we educating those people to make good decisions and prudent decisions on behalf of the plan? And do we have a good process by which we get that information back to the board of directors? In the second quarter, fees and services continues to be one of the easier areas for review and scrutiny, whether it's by a litigator, the Department of Labor, or a participant. So having a good fundamental understanding and annually auditing those expenses and comparing them to the relevant marketplace is clearly a best practice, and you would hope would reduce tremendously, not necessarily the risk of litigation, because you have no control over whether a case will be brought, but your ability to get a case dismissed rapidly. In the third quarter, we're looking at employee engagement type issues. How effective is the participant communication program? Are we getting the necessary disclosures out to participants to, again, abridge or reduce our fiduciary liability? Many of those disclosure requirements are just that, requirements, and failing to provide them is a breach in and of itself. Looking at some of the services that can incur additional cost. For instance, a number of plan sponsors, through their providers, have chose to extend participant-level advice or managed account services. Are you looking at the effectiveness of those programs and the impact of cost on participant returns? And then the fourth quarter, the plan operations piece. It's the piece that committees frequently overlook, but is an important element of the plan. So if you're a plan which is governed by the Employee Retirement Income Security Act, you may potentially have 404C compliance procedures to review. You likely have a Form 5500 filing to review. For most of the folks on the call today, your plans are auditable. You've got a year-end audit report to review with the committee. You probably have some element of compliance testing to make sure your plans have successfully met their non-discrimination requirements. All of those things are important additions to the normal and regular and necessary and important work of reviewing investment performance of investment products within the plan. with that, I'm going to hand it over to Bonnie to talk a little bit about the best practices pertaining to setting up an effective committee. So we've hopefully given you some ground rules as to how you may want to operate a committee, but how do you get one up and running and identify the right people?
Perfect. Well, thank you, Eric. Thanks for setting the stage with kind of that litigation landscape. And as Eric mentioned, I'm going to continue to shift our focus into establishing and running a retirement plan committee. And as we do that, I want to kind of set the stage a little bit more with some of the guardrails from the Department of Labor and some of the things to think about as we look at all of the tips that Eric and I will share throughout the rest of today's presentation, some of those DOL guardrails that we should keep in mind as we look at all of these tips. So if we look back, some of you may be familiar with this piece from the DOL called Meeting Your Fiduciary Responsibilities, and it really sets some of the groundwork. It was a 2012 piece, and it outlined 5 things that fiduciaries to retirement plans need to keep in mind and need to do as they work with retirement plans. And that includes carrying out your duties prudently, as Eric mentioned a moment ago. Second, acting solely in the interest of the plan participants and beneficiaries. Third, following the plan's documents. Fourth, diversifying plan investments. And then fifth, paying only reasonable fees, or paying no more than reasonable fees. And most of those are really self-explanatory, but the one that I want to come back to for a moment is the prudence element, because that's really going to be a lot of what we talk about today and a lot of what you do in your role. And a lot of times I think the question comes up, well, what is prudence, or what is a prudent process? And really the prudent process, you have to have an objective process. You've got to review all relevant information, or that which you should know to be relevant information. You have to conduct a meaningful comparison of information, and then you have to arrive at a well-informed decision. So I want to keep that in mind as we discuss these tips to avoid litigation, because as Eric mentioned, you can't always avoid litigation or avoid someone filing that claim, but if you followed a prudent process and you've got the documentation to show it, then you can easily or more easily get out of that claim pretty fast with a motion to dismiss or a motion for summary judgment. So keeping that in mind, I want to jump into how to establish and run a retirement plan committee. So the first thing to keep in mind is that ERISA doesn't require that you have a retirement plan committee, but it has certainly become an industry-wide best practice to have a committee. And I think later on in the presentation, Eric will have a visual that demonstrates a few different ways that you can attack that committee structure. But the thing to keep in mind is that while you don't have to have a committee, it certainly helps to have a committee and have a well-run committee when you go to defend against litigation. So, first, when you think about the membership of that committee, I think there's 2 things you really want to keep in mind. The first is probably what jumps out to you is the knowledge base of those participants on the committee. Who should be on the committee? You want people that can get the job done in terms of knowledge base. So when you think about what the committee does, they work on investments, but they also work on things like selection and monitoring of service providers, as well as administration and reporting. So not everyone on that committee needs to be an expert at investments, but consider a committee that can contribute to those other areas. Perhaps you want someone who has some experience with procurement, for example. Just think in terms of a committee that can contribute to the other areas, not solely investments. But the second thing you want to consider is just simply the ability to participate. So what does that mean? You want people who can actually show up to these committee meetings. So if you had a committee that was simply made up of the C-suite and scheduling was simply impossible, what's that going to look like to a plaintiff's attorney if you've assembled a committee but then you never actually met, or you only met once a year because you never could get something on the calendar? So just consider that you want some ease of scheduling when you go to assemble that committee. So next, once you have a committee, you want to consider that the board or the named plan fiduciary will need to delegate to that committee. So what does that look like? Again, ERISA doesn't require that you actually have a committee charter, but industry best practices seems to be that using a committee charter is really the way to go. So you don't have to have that under ERISA, but if you have a committee charter, which is a written document where that named fiduciary or the plan administrator is delegating responsibility down to a committee, that really seems to work well for committees because first, it gives an opportunity that as you have new committee members come onto the committee over time, they can take a look at that committee charter and get an expectation of what they're supposed to be doing on this committee. It also really helps, you can pull that out of your file if you're ever in litigation and have something to demonstrate how that responsibility was delegated. Just make sure that if you do utilize a committee charter, that you actually follow it. So once you have a committee in place, you will want to have some sort of policies or practices rather as to how this committee is going to function. So it doesn't have to be like a formal document of policies, but there just needs to be some consistent standard. So for example, how often will the committee meet? From our perspective here at Multnomah Group, I think we find that it generally works well, and of course this varies based on the committee, to have quarterly meetings. And typically those quarterly meetings need to be about 90 minutes per meeting. So you've got 4 90-minute meetings per year. That being said, some committees may need more, some committees may need less. We work with some committees and they only meet twice per year, and that can work well too. But you want to commit to some sort of standard and make sure that committee members are aware of that expectation. Likewise, you need to determine who's going to set the agenda for these meetings and what will we cover at the meetings. So for example, the fiduciary program that Eric showed a few minutes ago, as you noticed, it didn't just cover investments. So Eric talked a little bit about the 12 cases that were filed back in August of last year. And one of the things that you may have noticed is that those cases weren't just about investments. So several of the claims, or at least some of the claims, dealt with service provider issues. So the selection and monitoring of service providers, or one of the claims that may have popped out to you was the lack of a competitive bidding process for the record keeper. Well, if all you did is talk about investments at your meeting, you would have been potentially a target for a claim such as that because you didn't deal with the selection and monitoring of service providers. So just keep in mind that when you set that agenda, you want to have it cover things other than just investments. And then finally, last but not least, is about the documentation. So you want to make sure you know who's going to take minutes, who's going to record the action items so that you've got those for your next meeting, and who's going to keep what I would call, I refer to it as a fiduciary file, but all the important documents. Maybe that's a knowledgeable retirement plan consultant. Maybe it's someone you've appointed as the secretary of the committee, but you've got to have someone who's going to be the secretary or record keeper for your committee. So that's just a high level on establishing and running the retirement plan committee. There's a lot more you could cover there, but that's some best practices that I think we're seeing with a lot of the plans that we work with. So next we'll go ahead and jump into selection. Oh, actually I think next I'll hand it back to Eric.
Sure. We'll talk about the selection, monitoring, and replacing of investment vehicles because, you know, whether you look at the 12 class action claims in higher education, or if you look at the big settlements over the course of the last 3 or 4 years, in addition to fees, certainly investment monitoring is a pretty critical component of what much of class action litigation seems to be focused on. And a big piece of it, as with all elements related to fiduciary duty, is this demonstration of prudence. And in putting together documentation related to prudence, I think it's important to separate process from prudence. So another area where we see some significant challenges among new clients frequently is their process for monitoring investments. It's very rare that we walk into an engagement wherein a client has not been monitoring investments. But what we find with great regularity is that the process for monitoring investments is one of looking at solely quantitative data and then making decisions based on things that have happened historically to drive investment strategy and decision going forward. So for instance, a committee may say, if we have a product which is in the bottom half of its peer group on a 5-year basis for 3 consecutive quarters, it'll go on watch list, and if it happens for 5 consecutive quarters, it'll be recommended for removal. That is a process. Unfortunately, there's a great deal of academic data that would support that a process such as that one is imprudent because it generates on a recurring basis underperformance. What it tends to do is have plan sponsors firing managers at periods of historical underperformance to replace them with managers who have overperformed over the same period of time. But because of market cycles and reversion to mean, what that ultimately does is result, well, in a broad mutual fund type category in buying at highs and selling at lows. And if you do that with any regularity, you will generate significant underperformance for the plan and for obviously the participants who are impacted. So from a prudence perspective, I think having a process that is one driven by qualitative data rather than quantitative data is the critical piece. Clearly, there is always some element of trying to quantify investment strategy, and some elements are very, very good from a quantitative perspective about judging future performance. I'd look at one like expenses. I'd look at one like manager tenure. I'd look at one like manager skill and say, well, these are elements where we can quantify, measure what has happened historically, and if there's continuity among the group and the strategy, that we would expect similar type outcomes in the future. But where ultimately the important work gets conducted in the quantitative due diligence side, because this is where a good plan that's using an effective process can better assess the opportunity for performance, good or bad, to repeat in the future, which is really what we're worried about. Whatever happened yesterday has happened. Changing a fund because it has underperformed yesterday does not have any impact, obviously, on how it will perform tomorrow. But looking at these qualitative factors like investment process and philosophy, firm stability, shareholder friendliness, compensation practices, asset-based growth and distribution for mutual funds has a significant impact on performance. Those type of qualitative assessments tend to be much more productive, in reducing the frequency in which you have to change investment products, which under the new fee disclosure regulations and blackout requirements has become more and more cumbersome and time-consuming. So certainly reducing that type of disruption is important, but also tends to generate better performance because we're not doing the types of things that would cause us to cyclically hire managers at inopportune times. When looking at that manager and replacing investment process, looking at the totality of what you're trying to get accomplished, we think is important. When we get retained by a new client, the first thing we want to do is make sure that a fiduciary governance program has been established. So we get back to the things that Bonnie's mentioned about who are the right people, are the right people in place, and have they the right amount of training to make good decisions. The second factor is looking at the demographics of the organization. Is it a manufacturing facility? Is it a retail facility? Is it a food service facility? Is it higher education, engineering, law? What types of employees do we have? Because that will dictate ultimately the recommendations we make. A big piece of it is defining objectives. I think in the defined benefit world, one of the great benefits was we all knew what the objective was. The objective was to make sure that the plan was fully funded, that there was low volatility of potential return outcomes, and that the plan sponsor had adequate resources to make good on the benefit promises. I think trying to drive consensus about objectives and a defined contribution plan becomes more murky. I think some participants and committee members want plans where they can defer income and accumulate large amount of savings. Others want to generate plans that are much more effective at replacing working income over long periods of time. But defining the objectives ultimately will create the process by which a reasonable committee can arrive at consensus about the types of investment menu structure they're going to have. Once you've defined investment structure, then you're looking at asset classes, then you're looking at investment managers and products, and ultimately you're returning to communicate that to employees. There is no one right investment venue for any client. Across our client base, which I assume is similar to others, you would be hard-pressed to find two investment venues that are the same, because ultimately the differences related to demographics, strategy, and communications has a significant impact on the types of investment products and even the asset classes that you might choose to use. But from a prudence perspective, it's documenting these processes. Going to the Department of Labor, or certainly if you're in a class action litigation perspective, and saying, hey, this fund underperformed this period, therefore we fired it, isn't prudence, it's process. And again, separating and understanding the differences, I think, is critical. I'm going to hand it back over to Bonnie to talk a little bit about the monitoring of vendors as opposed to solar investments.
Great. So as I mentioned earlier, I think Eric just covered a critical topic about investments, but with respect to preventing litigation, there's more than just investments that we have to focus on. We also have to focus on things such as selection, monitoring, and replacement of vendors as well. So again, when we focus on vendors, we want to first take a look at the service providers to the plan today. And we want to say, who are the providers to the plan today? And is there documentation in the file for how each of these providers or vendors was selected? And is there also ongoing documentation as to how we're monitoring these providers? And if the answer is no to any of those questions, then it's time to go through this exercise at the next committee meeting and to get this into the minutes. So we want to keep in mind that, Eric mentioned the fee disclosure regulations a few moments ago, and we want to keep that in mind that under 408B2, which was that new rule from 2012, this is really critical because any service provider that enters into a contract or an arrangement with the plan, whether that's a written agreement or not, they're a covered service provider if they expect to receive $1,000 or more in compensation in that year. And so if they're a covered service provider to the plan, then you need to make sure that you're reviewing the reasonableness of the fees and then documenting that accordingly. So, then that really raises the question of what is reasonableness. So, we go through this initial exercise, we figure out who are the covered service providers, do we have documentation of that, but it doesn't just stop there. We need to make sure that we're doing this on an ongoing basis and monitoring that, again, reasonableness, that word reasonableness, on an ongoing basis. So then, what does reasonableness mean? Does it mean the cheapest? No, absolutely not. And, there's a lot of material out there on what reasonableness is, and I've provided a couple of quotes from the Department of Labor, again, looking at that meeting your fiduciary responsibilities piece. And the Department of Labor doesn't make you say, yep, it's the cheapest, so that equals reasonable. In fact, it's somewhat the opposite of that. Reasonableness means that you look at the fees in light of the services that are being provided, and you measure that against the peer group in the market. That kind of leads to the next point, which is that the department also says that you need to look at more than just the fees themselves, because a prudent process requires that. So the department suggests that you look at things like the services of that service provider. So also taking a look at the policies and the practices of the service provider, and any participant or beneficiary complaints about that service provider and how those were handled. So what are some examples of that? You could see perhaps maybe you have a service provider and they have the cheapest fees in the business. But if you take a look at that vendor and see that they cannot properly facilitate, maybe it's the loan process, maybe they're not able to provide the documentation that's required for participants as well as the plan sponsor, and that creates some sort of regulatory problem, then perhaps, if that's going to become a recurring problem, then you would need to reevaluate that provider. Or maybe it's a totally separate issue. Take a different example of maybe you have a vendor, and again, they have the lowest fees, but they have a very limited investment platform, and so that just doesn't align with the goals and objectives of the plan. Those are things that you can take into consideration, again, in conjunction with the fees. So that's all part of your reasonableness analysis and your prudent process. So, this is a super high level on the selection, monitoring, and replacing of vendors. But we could do a whole nother webinar, and I think Eric's probably done a webinar or two on this in the past. But the point here is that to prevent litigation, to prevent some of those claims that we saw in the 12 cases recently about the failure to go through a competitive RFP process, you want to make sure that you've got the proper documentation in your file and that you're properly going through the 408B2 analysis and documenting that accordingly, and be sure that you're doing that to prevent some of those claims. So with that being said, I'll move on to our next tips that we wanted to cover today, which is about communicating with participants. So we know that under ERISA, plan sponsors have certain things that you have to do to communicate with participants. So those are things, these are requirements under the rules, like sending out your participant disclosures quarterly and annually under 404A5. You also have responsibilities to provide things such as the summary plan description. Those are things that you have to do, that's not optional. That being said, there's additional communication that you can do with participants that would help to prevent litigation and also help to prevent angry participant phone calls to the Department of Labor. One thing I wanted to mention is that we've talked a lot today in terms of litigation, and I think we focused mostly on litigation where the plaintiff is a participant or participants and their beneficiaries. But another plaintiff that you can have is the Department of Labor, right? So under ERISA, one of the claims that you could have, or claimants that you can have, is from the Department of Labor. So to avoid both the Department of Labor coming after you as well as avoid litigation from participants, what you want to do is make sure that you're having proactive communication to participants, as well as preparing for the types of questions that participants and beneficiaries may be asking you, so that you're proactively providing responses that will prevent litigation or prevent the Department of Labor from knocking on your door. So what does that mean? What types of questions should you be prepared for? This is just a high-level bullet point list of some of the questions that we see plans encounter, but things such as fees and expenses. So ever since 2012, with the new fee regulations, it did highlight fees and expenses a little bit more. Next, plans, features, and benefits. So these are questions about who is eligible to participate in the plan and when. For example, can you imagine if you answer the questions wrong about who's eligible to participate, and you tell someone the wrong answer, and then they later find out they actually were eligible to participate? Next, administrative questions. So these are just the basics of, how does the plan operate? Where do I get information about how to take a loan? Are hardships available? Those types of things. The next one, investment-related questions. So these are the types of questions like, is the gold fund available in our plan? Why isn't it available in our plan? Or what about a self-directed brokerage window? Those types of questions. And then last, who is a fiduciary to our plan? I think 2 years ago you would have never heard that question, but ever since the John Oliver video that some of you may have seen or may be familiar with, some plans started to get a few more questions around, who's a fiduciary, and particularly in light of the fiduciary rule and some of the administration's work around that fiduciary rule after their February 3rd memo to address that rule. So those are some of the questions you maybe want to start to think about. And then we'll move on to the next slide to talk about how you could prepare to address some of those. So again, just a few high-level best practices. First, who is designated to answer these questions? So one of the things that we've talked to a few of the committees we work with about, should committee members be designated to answer questions from plan participants? As a best practice, we would typically suggests that you have a designated person or a team of individuals to address participant questions, and typically those individuals are located in the HR office. So generally you don't have your whole retirement plan committee running around answering participant questions. And the reason for that is that you want to be able to have someone in the HR office be able to document things like who is asking the question, what is the question, and how did we respond to it, just so that you can have a record for that. So, you know, for example, along with that, you want to maybe have some pre-prepared materials. So maybe it's a fact sheet or something of that nature. You may also want to have some sort of high-level policies to be able to address some of these things. So for example, one committee that I'm working with, we created a high-level policy on how to address when participants come in and ask to review the plan document. And we created a policy that we can make available to someone in the HR office so that when a participant comes in and says, hey, I want to see the plan document, they have a policy in place for how to address that question. One of the top things in that policy is to make sure that the person asking is actually a participant in the plan and not just random plaintiff's counsel walking in the door to ask to see that. Second, you want to make sure you have someone to escalate questions to when the answer is unknown. So maybe it's not something that you've attacked before and the HR person doesn't know how to address the question. So who is it that can get elevated to, and what's the timeline for elevation? So for example, maybe it's a more complicated question about fees that needs to get elevated back to someone at the record keeper or someone at your retirement plan consultant's office. You want to make sure you have that name, contact information, and a timeline for response. What you, again, don't want to do is let that participant's question sit there, be an unanswered question that's never resolved, because if you have an angry participant who doesn't get their question answered, then that's when they may end up calling the Department of Labor. And most of the time, Department of Labor, when they start an investigation, it's because of some sort of reason, typically because a participant called and made a complaint. So we don't want to let participant questions go unanswered. The third thing, you know, you want to make sure that you document these points of interaction, and then that kind of leads to the fourth, which is to monitor that. So they go hand in hand. If you document your interactions, again, kind of the who, what, when, potentially the why, then you can monitor those and maybe create some additional FAQs or proactive communication to participants over time. So if you have a lot of participants coming in and asking about a self-directed brokerage window, for example, then maybe that's something that you want to consider as a committee. Or maybe you have a lot of participants who are asking a certain question about fees that they don't understand. Then maybe that's something where you'd want to do a group education on fees in the plan, something of that sort. So if you continue to monitor that over time, then you can create proactive communications accordingly. So I know that was a lot thrown at you in a short time. I'm going to throw it back to Eric to cover our last point today, which is then how to, you know, in that fourth quarter or thereafter, work on reporting back to the board.
So in the overwhelming majority of clients we see, the plan document is structured in such a way, especially if it hasn't been drafted by outside counsel, where the organization is the plan sponsor and ultimately carries the fiduciary responsibility for managing the plan. So generally, in those instances, plan sponsor meets board. So if you're a tax-exempt organization, it would mean your board of trustees. In a corporate scenario, it would likely mean your board of directors, unless it has been otherwise delegated. So Bonnie has already talked about the frequency with which ultimately those responsibilities are delegated. Boards, both in tax-exempt scenarios and certainly in corporate scenarios, are overwhelmed with both strategy direction and review and governance. So adding yet another relatively detailed and very specific element to that typically is not within the goal set of most organizations. As a result, within those charters that Bonnie addressed, there's really a couple of different structures that we see. Option A for typically larger and more complex organizations is a delegation to a retirement plan administrative committee that handles much of the administrative fiduciary diligence work that both Bonnie and I have discussed today, and then separately a retirement plan investment committee that addresses the investment issues. The charter then would define those issues that may touch both and how decisions are made in those entities. But if you have a plan or set of plans where the issues are certainly complex enough, that allows you to use your best people to find the scope of the work that they'll be working on to try and drive the best outcomes. What is more common, especially in mid-sized and certainly smaller organizations, is option B. And in this case, you have a board which ultimately delegates the fiduciary responsibility of the plan to a retirement plan fiduciary committee. And that retirement plan fiduciary committee typically does all of the oversight elements of the RPAC and the RPIC, the Retirement Plan Administration Committee, and Retirement Plan Investment Committee, as mentioned earlier. For mid-sized organizations, the group of people that has specified knowledge related to retirement plans, be it administrative or investment, is small, and you're trying to get as much work out of that group of employees as you possibly can. Regardless of how you set it up, I think there are a few critical issues to keep in mind. The first of which is defining the level of indemnification that the organization will provide members of these committees. We're talking about what is potentially fiduciary breach suits. Those fiduciary breaches are potentially individual to the committee members, and as a result, it would be appropriate in most instances to have some level of protection or indemnification for committee members acting in good faith under either structure. Another is certainly the demonstration of delegation oversight. So it is best practice to develop a charter that defines the level of delegation from the board to a committee or group of committees. However, because the plan documents define the fiduciary as being the board entity, merely delegating and never reviewing the quality of the delegation would certainly seem to create an opportunity for an enterprising plaintiff to claim a lack of oversight. So being able to circle back around from the committee on at least an annual basis to report on the progress made doesn't have to be long form, but clearly demonstrating that the committees who are operating as fiduciaries in these plans understand their responsibilities and there still is oversight. And if necessary, clearly the board would be in a position to rescind any delegation that's made. Another, going back to some of the information that Bonnie talked about, is really defining membership development and training. One of the things that we've noted in reviewing a number of recent letters from the Department of Labor collecting data from plan fiduciaries is additional questions on the method by which fiduciaries are trained. So if you are putting together a committee, I think those people need not be experts necessarily in any of the areas related to retirement. However, in all cases, whether they have great levels of experience or very little experience, it would be prudent, at least as suggested by the Department of Labor, to have a process by which committee members get educated over time and become greater experts the longer they continue with the committee. And I think the last issue that ultimately organizations have to decide, and part of it's cultural and part of it's risk mitigation, is to what level will the board be involved or not in managing decisions made by the committee. For most organizations, given the level, again, of responsibilities by their board, the effort is to try and immunize those people from fiduciary breach liability. And most ERISA attorneys representing clients that we work with would suggest that the best way to do that is to provide a very full and thorough delegation to the retirement plan committee and to not micromanage decisions made by the retirement plan committee. However, there are certainly organizations that, because of their culture and history, have much more involved boards. And in the case where, in some instances, even where members of the board or extended board committees may serve on these retirement plan fiduciary committees, administrative committees, and investment committees. Any of those structures can work. What is important, I think, is to define exactly how this particular organization wishes their delegation to work, and to ensure that ultimately, if you're sitting in a room being deposed by plaintiff's counsel or in an interview room with the Department of Labor, that the board and the committees are on the same page as it relates to what's been delegated and what the process of oversight may look like. So, with that, I'm going to open up for some questions. I'm going to throw a couple at Bonnie while I pull some of these off the Q&A. I see some have started coming in. But the first one, Bonnie, I wanted to talk a little bit about was the process. As I understand it, and you can correct me if I'm wrong, in the majority of instances where a class action suit is brought, or any action is brought by a plan participant against a fiduciary, they get counsel. The participant, or probably counsel on behalf of the participant, drafts a letter requesting almost everything but the kitchen sink as it relates to information, right? They say, I'm a participant, I want your investment policy statements, your last 3 financial statements, and some of which are documents that they may be legally entitled to, and some of which are documents that they're not legally entitled to, but the plaintiff's counsel would like to see to determine, whether there's a case. Do you have any thoughts, notions, best practices on, if you get that type of letter, what your next steps should be as a retirement planning committee member?
Sure. So I think, step one is immediately, if you ever receive any sort of demand letter. So I think a lot of times before anything's ever filed with a court, oftentimes you may receive a demand letter, which is kind of the first step of, I would say, send that demand letter to your counsel immediately, and then let them start to assess the situation. So I think that's where you can take first steps to work with counsel, and I would say, likely that would need to go to outside counsel, specifically some kind of ERISA counsel, ERISA litigation counsel, to be able to start to assess. Once something is filed in court, then when you've got that complaint phase, then that'll kick off the discovery phase. And Eric, I think that's what you were referring to. Once you're in that discovery phase, there's a whole lot of back and forth of document collection. And that's where I think a lot of times plaintiff's counsel starts to figure out, do we have a case here or not? And so if you've done a lot of the things that we've talked about today, where you can demonstrate we've got this great file, then that's where the case starts to go away pretty quickly. Whereas if the plaintiff's counsel can figure out, we've got a lot of gaps in their documentation, that's where then the case moves forward. So there was a case, and I can't recall the name of it off the top of my head, but we had looked at it last year, and it was a California case, and it ended up getting thrown out. It was against a smaller plan, and that's why it really made some headlines, is because it was one of the fee litigation cases in the retirement space that actually was against a smaller plan sponsor, and so that's why it was pretty notable. But it ended up getting thrown out because I think they really had some good documentation, and unlike some of the other cases where there's not as good of documentation, then they were able to get that dismissal.
Next case or next question, maybe you can give some thoughts too. Since so few of these cases actually get litigated all the way through judgment, there hasn't been the opportunity to create quite as much case law as there might be other places. And then looking even at some of the amended claims by firms like Schlichter, they're essentially using some of the settlements that were made in previous cases and are implying that those types of settlements now are best practice or industry standards for new organizations that they're litigating against. Any thoughts, perspective on how plan sponsors should view some of those litigation outcomes?
Yeah, I think that's a great point, Eric, is that, there's two things working against plan sponsors here. Is one, there's a lack of case law, and two, because of that, so case law also referred to as common law. So because these cases, number one, aren't making it all the way. Number two, I think a lot of judges are hesitant to basically pave the way, so they, just stick to the black letter law under ERISA. So in a lot of areas of law, common law is made because the judges rule on things, and that creates new law. That doesn't really happen as much as in ERISA because they settle, and then judges are a little bit more hesitant to actually create new law. They just stick to the black letter law of ERISA. So because of that, then we have people like Schlichter saying, they point to these settlements. But I don't think that plan sponsors should take that as a sign that, these settlements are actually law. They should stick to the rules under ERISA and stick to the principles like what we discussed at the beginning of the presentation and throughout. What is reasonable, what is in the best interest of participants, and then document those things accordingly. So by doing those types of things, as long as you're doing what's reasonable and documenting that, sticking to your process, those are the types of things that really matter. A settlement doesn't, that's not case law, and so that doesn't create new law, even though someone like Schlichter may want you to believe that or may want to create that perception. That's not actually the law. So, by sticking to the basic principles, and there is some good DOL guidance. So there's things like the meeting your fiduciary responsibilities, and there's other pieces. The DOL has a nice piece on fees that's out there as well. I think that's from 2013. And then likewise, the IRS has some good pieces as well. So by sticking to some of the principles in those pieces, I think that can be some helpful documentation.
And I think there's one last question before I close it up today. We had a request. You had mentioned kind of the guardrails earlier, Bonnie. Could you repeat those just at a really high level?
Oh, sure. And I can also, I think we can send that the person asking that question, that DOL piece, meeting your fiduciary responsibilities. But the 5 principles or guardrails, as I referred to them in that piece, are first, to act solely in the interest of plan participants and beneficiaries. Second, to carry out duties prudently. Third, to follow the plan's documents. Fourth, to diversify plan investments. And fifth, and finally, to pay only reasonable fees.
Great, thank you. I want to thank everyone again, and Bonnie specifically, for today's presentation. I hope we've had an opportunity to answer the questions that we've generated. But again, as I mentioned earlier, please do feel free to reach out to either Bonnie or I. We'd be happy to address any follow-up questions. Do keep an eye open for both a copy of today's presentation and materials, as well as the availability of a link to the presentation if there's information that you want to go over at a later date. We thank you so much for your time. We know how busy everyone is, and look forward to speaking with you all again soon. Thanks so much and have a great day.